Live from Chattanooga, Tennessee, it's Nuganomics with David Toulis.
There are three candidates for criminal court judge. Tom Greenholz, nominated or named by Governor Haslam to the bench in that division, is the incumbent. He is seeking election for the first time. Also Boyd Patterson, who is a prosecutor, and also Mike Little, who is a defense attorney. Mike and his wife Lynn have three children. He works in the public defender's office. He is the deputy public defender, which is like an executive assistant, and he helps Steve Smith, who is elected to oversee 14 assistant attorneys who are named by the state to identify or to defend people who don't have enough wherewithal to hire their own attorneys and to maintain their rights. Mike, how long have you been a public defender?
I've been working in the public defender's office here in Hamilton County for 16 months.
Is the public defender's office one that vigorously prosecutes trials, or is it known more for copping pleas among defendants?
Well, what we do first of all is whenever the court determines that an accused is indigent, and then our office is appointed. We don't solicit business or anything like that. We simply, court appoints us and we take the case. And if we don't have a conflict for any other reason, then we take that case just as if we were hired, and we represent the client, and we make sure that his rights are protected, and we give him advice, and pursuant to whatever he decides is best for him, we pursue a strategy.
Well, how often is it that cases go to trial of the body of defendants that you have in a year?
It's rare. It's rare.
Why is it rare?
Well, most cases are settled. If a client is accused of a crime and the facts are present themselves where the likelihood of conviction is great, then the defendant has that, after considering all of his advice and looking at what the state can put against him or introduce a trial against him, he has the right to make a decision. And sometimes if the government makes an offer, which would be the district attorney's office, if they make an offer in a case and the offer is less than what he would get at trial, if he thinks he's going to be convicted at trial, then he can make that decision based on advice to plead guilty.
So most defendants who are served by the public defender's office are convinced, either they convince themselves or they hear the advice of one of the 14 assistant attorneys to make a deal with the prosecutor, get some kind of lesser sentence, and not go to trial.
And that's not just in the public defender's office. That's typical in representing a defendant overall, whether you're hired or you're not. It's not just in the public defender's office that occurs.
Well, is there not some way that more trials could be forced upon the state, making the district attorney earn his pay? District attorneys often are very well versed in negotiations, but hardly, in some respects, hardly enough in courtroom proceedings. And is it not in courtroom proceedings, Mike Little, that the validity of laws is established? If juries keep rejecting a certain line of prosecutions, is not that a signal to the legislature to change the statute to stop prosecutions in a certain line of offense? And how can we determine whether there's bad law out there unless you defend defendants and make the prosecutor fight for his conviction?
Well, it comes down to the facts in the case and what the evidence is. We have a lot of cases that are dismissed, and those you don't see. Those they normally don't get the publicity that some of your cases get, where people actually plead guilty. But there are a lot of cases that are actually dismissed as well. People who have been overcharged or wrongly accused. Those cases, through the work of the attorney and the investigation of the team, that happens.
When you say overcharged, what phenomenon are you describing?
Well, I've always, I've been practicing for 18 years, and what I've always considered when I look at a case, any criminal defense lawyer is going to represent what I consider. You can place them in three different categories. One is the person who has been accused after the evidence is presented may have actually committed the crime. That's possible. The second area that I consider is someone who has been overly charged. They've been charged more than what they should have been charged for. So, for example, if someone is charged with first-degree murder, and it turns out that it was actually an accident, it may be in a negligent homicide case. That is an example of someone being overcharged. And of course, the third category that I look at is someone who is wrongly accused.
Well, or not, there is a phenomenon in modern jurisprudence that's called charge stacking, and you said overcharge. Charge stacking is the term that I've read about, and there you'll have 6 or 7 accusations of, let's say, a defendant who fled from the scene of an arrest and got involved in an accident and may have had a handgun. So he has about 7 or 8 charges in addition to the assault charge, which was the cause of the chase. Is that something? Is charge stacking a method whereby the state bullies defendants into submission and plea agreements?
No, I don't see that. What I see is whenever a police officer or law enforcement engages in any kind of investigation in the case, whether he's actually a part of, direct witness himself, if he sees any violations of the law that he thinks that rise to the level of probable cause, then he can make that arrest and make that charge by affidavit of complaint. Now, it's up to the prosecutor to determine whether he wants to pursue that prosecution in all those cases, and then if the defense has a defense on any of those charges, then they're able to litigate them. So I don't see that as something that is a problem. So
charge stacking is not a problem in Hamilton County. Unjust piling on of charges to bully the defendant into submission.
I don't think so, and we're not going to allow that.
And on the other hand, you would then say also Mike Little, candidate. This is David Tullis. We're talking with Mike Little, candidate for criminal court judge. In the Republican primary, all 3 candidates will be decided in the primary March the 1st. Early voting, by the way, Feb 10 to what's the date?
23rd.
The 23rd.
February 23rd. That's the window for early voting.
Early voting. Mike, so you'd also say, just as prosecutors can't fairly be accused of engaging in the sin of charge stacking, that the public defender's office is not a plea bargaining mill where everybody just is run through pro forma.
No, we represent our clients, and depending on what the facts are in the case, the client is given advice, and the client makes the final decision. We don't force anybody to plead. We don't force anybody to go to trial. It's up to the client.
My listener has a prejudice. Now, I would like you to address this prejudice, Mike Little,
glad to.
And that is that the court system grinds the common man down to the ground. It's a fee skimming operation. The people who mill around in these courts are often the poorest of the poor. They drive old cars. Their offenses often are paper offenses. They're victimless crimes. No tag, no license, gun without a permit. Accident, no insurance, and things like that. And so the people who are the most abused by the judiciary are the commoners, not the white collar types like you and me, but the common people who have bad grammar. They have 2 jobs, they have debts, they wear old clothes, they're sort of shabby in their appearance, and the dad has bad teeth. These are the people whom the court system seems to grind down and not care anything about. Is that, first of all, is that observation true or partly true? And if it is, what might be the remedy for giving a break to the people by the state?
I don't think there's any conspiracy or any orchestrated group of people who are out there to abuse those who are accused of crimes. What you will see sometimes in our system is that we're overloaded and overcrowded some days. Some days that we have a lot of cases that the people who are in courts the first time, or they've been there several times, and they may be for small offenses, and that may be their 4th or 5th or 6th time to go to court. And in that sense, they may be, look, I have to go to work. I have to take care of my kids. I can't come to work. I can't come to court I can't take off work or I'm going to lose my job. That does happen sometimes. And
those are your clients often, right?
Sometimes. So most of our clients are in custody. Because they're determined indigently. It's hard to, if you're in custody, you're not working. If you're not working, you're not making an income. So you're going to be indigent. So most of our clients are in custody. But that's not all. There's there is the defendant who comes to court sometimes and simply pleads so he doesn't come back. I've seen that happen.
Pleading for convenience.
But it's not any conspiracy or any kind of, I don't think there's any, I know there's not any kind of orchestrated governmental body making that happen.
This is David Tullis, and caller, you're live on the air with David Tullis and Mike Little, attorney and candidate for criminal court judge. What's on your mind?
Well, I'm so glad to hear Mike Little on the air. Good morning, Mike and David.
Good morning.
I've experienced personally over the past 35, 40 years, absolute total abuse from local judges. Not a federal judge, but local judges, where in one case, I wanted to defend myself, and they refused my right to speak under the 6th Amendment. It said, you have to get an attorney. And I find these local judges to be the most corruptible. And I also find that if they believe you know your rights, when you get in there a second or third time, you're the last to go because they don't want people to hear this. I'll give you a general statement based on being in court about 40 times on constitutional issues. So what are you going to do differently than the rest of these judges? Are they afraid of individuals bringing up constitutional law or the Constitution or their rights, or don't they care about it? Are they ignorant on it? I know I'm asking a lot of questions here. But overall, as a defense attorney, what have you seen in the system that you think has been corrupt in judges, whether it's monetary corruption, corruption through ignorance, or just downright being mean and not letting people speak? And what are you going to do differently than every other local judge that may not have a lot of training to protect the individual rights of that person? Because let me tell you, Mike, I think this position you're going for is more important than the Supreme Court. Because where you are, you can stop the tyranny right then and there. So,
okay,
go ahead.
First of all, I understand your question. I understand your feelings about the system, and some people have those systems. I don't totally agree with your premise, but you know what we do not want, and what I have seen over the last 18 years, sometimes is sometimes the court's crowded, sometimes it's busy, and sometimes the defendant goes before the court. He does not have a lawyer, and I've always thought that was the wrong thing to do. I don't care if it's a speeding ticket or on up. I've always felt that anyone who goes to court or anyone who gave me advice over the years, or I'm not advice, but asked me, hey, look, I've got this ticket or I've got this small offense. Do I need a lawyer? My response is always yes, whether it's me or somebody else. Now, speaking for me, the court is supposed to be independent, impartial, and fair. Now, those are not words that I'm making up. Those are words that come right out of the Judicial Code of Conduct. And that's what a court is supposed to be: independent, impartial, and fair. And where
independent of whom or what?
Independent of everybody. The court is independent. We're not favoring the government, and we're not favoring the defense. We are in the middle, and we listen to the facts and we apply the law.
And you're independent, even though you're paid by the state and the state's division, the county.
Yes. I mean, I'm that's correct. I mean, you have to understand that when you take the bench. You know, if the courts, the trial courts, and I agree with you, the caller, that the trial courts is an important court because that's where the trials are had. That's the court of record. That's where the trials are had. That's where justice is sought. And you know, justice is not necessarily for the prosecution about winning, but doing the right thing. And you know, justice is giving every man his due under the law.
And so, you're Mike Little, in your estimation, it is possible to be a just judge. It's not impossible to be a just judge.
No, it's very possible. I've seen it. I've been before over 30 judges in my career, and I know the value of the
federal, state, and local
municipal courts. I've been worked in 13 counties, and I've been in Knoxville and in Chattanooga in federal court. I've argued before the Court of Criminal Appeals, the Tennessee Supreme Court, as well as the Sixth Circuit Court of Appeals in Cincinnati at the federal level. And I have had good results, and I have seen fair judges who are independent and impartial.
And these fair judges, Mike Little, look at the statute and the law in view or in the light of the Constitution as well, many times, right? That's your assessment of these judges.
Yes, all criminal law, especially on the state level, which is my concern in seeking this position, is codified. In other words, it's all criminal laws are codified and are placed in statutes. The legislature makes the law. It's called positive law. It's man-made law. Of course, the Supreme Court is the Constitution, supreme law of the land, and it cannot violate the Supreme Court. I mean, the Constitution of the United States, as well as the state constitutional issues. Well,
is there a distinction between victimless crimes, Mike Little, and crimes? What's the distinction?
A distinction between victimless crimes. I mean, if there's I'm not so sure there is a victimless crime. I mean, you know, even if someone is charged with a DUI and no one's hurt, there's really not a victim, but society is the victim sometimes, and sometimes
because risk is increased by that person's being on the road.
Right. If they are guilty and they're not punished, then there may be a victim later on. So no, they're all crimes are against the peace and dignity of the state, and that's what the prosecution has to.
Well, how is that? Describe the peace and dignity of the state as a real thing? When a person who commits a victimless crime, let's say driving on a suspended or driving on an expired or no tags, how is the peace and dignity of the state offended enough to be actionable? How does that happen?
Well, in an example like that, there's really no, if you're driving without a license, there's really no true victim unless you end up driving and you have no insurance, you end up hitting somebody. And that's what we want to prevent. We don't want anybody getting hurt. So there's a law that says that you have to have a driver's license. So, and that's passed by the legislature. It's state law.
So that's compulsory?
If you want to drive a vehicle in the state of Tennessee, the legislature says you have to have a driver's license. And if you're caught in some traffic stop, and it's a valid traffic stop, and you're not driving with a license, then you can be arrested, or you can get a citation in lieu of arrest, but most are arrested. And you have to go to court to answer those charges.
Okay.
That is a crime against the peace and dignity of the state.
Okay. So, well, my listener has followed our work on this question of Title 55-5301, which is the driver's license statute, which is not, if you follow the rules of statutory construction, it is not compulsory. It is a voluntary mechanism allowing people to enter into an equitable relationship in commerce with the state. But that point aside, getting back to the question, Mike Little, of the victimless crime, you're saying there's not a victimless crime, and therefore the answer to my next question is you would not be in a position to show leniency, lenity, grace, or favor, or generosity to a defendant coming up for sentencing who is guilty of a crime in which no one has been hurt. Again, I'm talking about a paper crime.
Well, in sentencing, if someone is found guilty, then the law says that they have to be sentenced, and the court has to follow the law. I mean, the judge is sworn to that duty. He has to follow the law. Now, the judge first has to look to alternative sentencing. You know, if someone is driving without a license, they in reality probably should not go to jail. I mean, I don't think they should, and the laws allow that. We don't want to fill our jails up with nonviolent criminals, and I don't really think that, you know, I wouldn't even recall someone who's driving without a license a criminal unless they're declared that, and there's a way to do that. If you're
convicted on driving on suspended, then you're a criminal. It's a misdemeanor.
You've been convicted of a misdemeanor. That's correct.
So here's one little window that you're opening. You're saying that someone who is convicted before you of a victimless crime, what I would call a paper crime, you would try to find an alternative to prison or jail for that person.
We wouldn't try to. It would. The law, the sentencing statutes allow the court to look at alternative sentencing, which is not going to prison. You may have a sentence, or you may have a sentence to the workhouse, but you don't have to go to prison, or actually in custody.
Now, you as we're talking, this is David Tillis. We're talking with Mike Little, who is a public defender, a candidate for criminal court judge. The position is held for the moment by Tom Greenholtz, who was appointed by the governor. There was one other candidate for this position, Boyd Patterson, who is a prosecuting attorney on the side, always representing the interest of the state. It would seem to me that a candidate who is a defense attorney has already half a vote in his favor, because he represents the commoner, the common man, whereas the other two men represent the state in some fashion. The judge, the state itself, and the prosecutor always representing the state. Well, let me ask you about prosecutors. Why are cases styled State of Tennessee versus Joe Sixpack? Why not have the people of Tennessee versus Joe Sixpack or other? Why is the state the offended party when clearly in a rape, let's say, there's a woman who's been violated and she is an injured victim?
Okay. Well, the style of the case, the plaintiff always goes first, and so in a criminal prosecution, the state of Tennessee is the plaintiff, so they go first. State of Tennessee versus.
So it's the offended
John
party.
Doe.
It's the party that's been offended.
This is people of the state, by our legislature. It's the people of the state, the peace and dignity of the state, and so the prosecution is they by law prosecute crimes, and the crimes are again codified in the legislature, and that's their duty, that's their function. The victim in a case is a witness, and most often is the prosecution's witness, and they certainly have both. Normally have a desired result. So
the prosecution is not really for the person who's the victim, the rape victim, let's say. It's for the state whose peace and dignity have been offended by the rape of that person who is a witness now. And that's why the cases are styled State of Tennessee versus Joe Sixpack.
Well,
Is that a fair description?
Witness and a victim in this particular case. Yes, the style of the case, the plaintiff always goes first in the State of Tennessee is always the plaintiff because they are bringing the indictment.
And
which is the charge.
If it were a private suit, Mike Little, it would be Phyllis Jones, the rape victim, versus Joe Sixpack. If she were bringing the prosecution in civil court,
whoever files the original complaint is the plaintiff, and whoever answers as the defendant becomes the defendant.
This is David Toulis. We are talking with a candidate for criminal court judge, Mike Little, who has he's the father of 3 children. His youngest is 13. Very pretty girl. On his, you can see her holding a elect Mike Little poster on Facebook. 2 other children in the Little family, sons, ages 26 and 28. Mike is a public defender. His office is in the Tivoli Center on Broad Street. He is the deputy public defender in Hamilton County, overseeing 14 attorneys. This is David Toulis.
Live from Chattanooga, Tennessee, it's Nuganomics with David Toulis.
Make sure you sign up for your concealed carry permit handgun class at Carter Shooting Supply on Highway 58. Is the Tennessee handgun permit class at Carter Shooting Supply and Range on Highway 58, a place where you have great bargains on handguns and shotguns and rifles, great deals on ammo and all kinds of paraphernalia that pertain to the exercise of your Second Amendment and other. All right, so make sure that you have lunch very, very soon at Choo Choo Barbecue to test out whether or not you want to have barbecue for your next public event, your next catered event. I would recommend Choo Choo Barbecue. The number to call for catering is 870-7894, 870-7894. And there's pork, chicken, and beef, and there's a secret rub and a delicious smoked flavor on any of the meats and sandwiches and great salads there you will enjoy at Choo Choo Barbecue in Hickson, of course, right near Valley Brook. If you want to get into business on your own but don't have your own idea for what it would look like, contact Bruce Krebs today. Get on Bruce's calendar and have him at Entrepreneur Source fit you with a business, somebody else's business into which you are a buyer and a player. You become a local rep. And that, of course, is a franchise. And that's Entrepreneur Source, 875-5621. And Bruce will be your consultant. You don't have to pay him a dime for his services. He is paid by the franchisor if you go into a franchise as franchisee. You need to have a plan B, and that's what Bruce Krebs offers you. And if you have go into business and need some help with your numbers, make sure you contact the numbers guy, Eric Pelton at EJ Pelton Company. And online it's ejpelton.com. He has an office in Saudi Daisy, right not far from our tower, the tower of the powerful radio station, AM 1240 Hot News Talk Radio, with 1,000 watts pulsating out over hill and dale and some Confederate monuments. And also want to make sure that you consider joining us on all of our great shows. We've got Binary coming up after my show, the David Toulis Show at 11 with Russell the Kid. And we have Colin Cowherd from noon on, and at 3, Sean Hannity. In the evening, just at dinner time, we have Clutch with Keon Rose, our sports show. You will enjoy Keon greatly. He's a very intelligent young man and is a credit to our station. And we do encourage you, if you are sports-minded, to tune in if you're going somewhere or have some downtime in your cranium. Tune in to Clutch with Keon Rose. I'm David Toulis. You're hearing us on your smartphone and also on YouTube. We are live on YouTube, and there are 2 men standing here in front of our elect Mike Little sign. One has a red tie, one has a red bow tie. I'm the bow tie guy. And with me is Mike Little, an attorney. He's a married man, 3 children, had a late surprise in his marriage. He has 2 sons, 26 and 28, and then popped in to the Little's family, a daughter age 13. He's a public defender and makes Steve Smith look good, makes everything happen for Steve Smith, the elected public defender in Hamilton County. And together, these men oversee 14 assistant attorneys who defend the paupers in our town who can't afford their own defense, but who have rights to be defended in court. Mike, if you become criminal court judge, what would you bring? Tell my listener in a nutshell what it is you have to offer. Why should he care a whit about you?
Well, Hamilton County Criminal Court is a very important court, David. It is the trial court. It's a court of record. Serious cases go into criminal court. Homicide cases, sex offense cases, violent crimes, drug cases, DUI cases. A lot of serious cases to go into trial court. And that is where the defendant exercises his right to a jury trial. And so the state of Tennessee exercises the right to a jury trial. You know, why do I want to take this position? Because I've worked in criminal court for the last 25 years. I spent the first 6 years of my life, not my life, but my career when I was in undergraduate school and in law school. I worked for 3 criminal court judges, all in Division II. It's the same court that I'm running for now. I've been practicing for the last 18 years in criminal court, not just in Hamilton County, but all around in 13 counties practice in. And I've tried over 50 jury trials in state and federal court. That brings a lot of experience. I've not tried 1 case or 2 cases as a lead attorney, but 50 cases. I've picked that many juries. That is, so if you want someone to sit on the bench and litigate, and not litigate, but preside over cases, that individual, in my mind, needs experience. Someone who has been there, someone who has seen it. I've dealt with all the law enforcement agencies. I've dealt with thousands and thousands of accused and victims and witnesses in cases I've had to interview. So that in and of itself helps me become a good criminal court judge.
We live in a state that runs on grounds of commercial government, Mike Little. Everything is in commerce. Most of the state seems to operate in commerce. When you are a criminal court judge, do you adjudicate cases or administer them?
Well, what we do is we follow the law. Whatever presents itself in court. And basically, here's the way it works. If there is any kind of issue that is raised by one party or the other, the facts, there's evidence is introduced. The court allows that evidence in under the rules. But the court is neutral. We don't favor one side or the other. If you will, we have the blinders on our eyes. We listen to the evidence, and then with that evidence, we apply the law and make a decision. And that's in any case that comes before the court. A jury is the trier of fact, and they listen to the evidence, and then they apply the law as the court gives it to them. And the court does not sway any way, one way or the other, in that process.
But it sure can. In, say, jury instructions where there's haggling before the judge reads the instructions to the jury before they go behind the doors. What the judge says is the issue, or are the issues that can determine how the jury will rule, right?
Well, the judge has to present the law under the law. The court has to give whatever the facts of that case are. The judge has to give the law that's applicable to it. He's required to do that under the statutes in the law. All the law is codified, and procedure is approved by the Tennessee Supreme Court. The court has to follow that. I don't have the discretion to give certain instructions in a jury or not, unless there's law that allows that, and both sides make the argument, and then I decide based on the law.
So it's possible, Mike Little, despite the skepticism of my listener about the judicial system, despite his growing sense of the police state, especially with police brutality, it is possible, you're telling my listener, to be a just judge in Hamilton County.
Yes, it is. That's why I want to run. I want to be independent. I want to take that spot and be independent and serve on the court like it's supposed to be. It's independent, it's impartial, and it's fair. And the judge just takes that spot and has experience that I have. I can do that.
The Tennessee Judicial Rules of Ethics prattle on for about 45 pages, and it makes for some lively reading. I found a real sparkler in there on page 18, Mike Little, and I want to ask you about it because it seems like an out. It seems to me that there is an out in which judges don't have to do what you say that they are required to do, and that is, it's in one of the comments. It is about rules for disqualification, and of course, say just briefly, how would a judge be disqualified in an event? Explain the concept, if you would.
Disqualify from a case?
From a case.
From a case? Well, if I'm fortunate to be the Hamilton County Criminal Court judge and someone comes before me that I have to rule on, and I know them from some previous encounter for whatever reason, then I would recognize that, and I would ask myself, I would step off of it, recuse myself. Another criminal court judge would take that. You avoid
or you would at least say something about that connection.
I would let both
and let someone else suggest.
Let both parties know there may be an appearance of impropriety here. It's not that I would rule in his favor. I wouldn't do that. But we want to avoid the appearance of impropriety, so I'd step away from it.
So a disqualification is when you say someone else says that a judge is disqualified for reasons of personal or professional connection or empathy, or the judge himself says, "Hey, I may have an appearance of some kind of empathy, which might make it look that I'm not being just." Okay, so that's what disqualification is. But in the comments on these rules, it says the rule of necessity may override the rule of disqualification, which says that if necessary, the judge doesn't have to follow all the 48 pages or whatever in these rules of judicial ethics, especially on the point of being qualified or not qualified to hear a case. How is it necessity can override a rule like qualification?
Well, there may be an issue that's brought up by one of the parties and lets the judge and points out to the judge that, look, there may be a reason here that you recuse himself. The judge may not agree with it. It doesn't mean I'll agree with it. But the one thing is, if a judge does not agree with it and stays on the case, he has to put in writing why he's not going to recuse himself. Mike Little, anytime Mike Little is presented with this kind of issue, I'm going to look at the law and I'm going to do what's right, and I'm going to avoid any appearance of impropriety.
So it's not just avoiding impropriety, Mike Little, it's avoiding the appearance of impropriety. And so
yes.
you would say that this out in the code of ethics that of the necessity out would not be an out that you would take. You would want to avoid impropriety as a judge and also avoid the appearance of it.
Right. If I find that that's the case, then that's how I'll handle that. And I think that's what any judge would do.
Well, the whole idea, though, my listener is worried about is the idea of necessity, because you've heard the old saying, touching on past despotisms, that the necessity is the tyrant's defense. We have a war with Germany, and so now President Roosevelt nationalizes effectively the whole economy out of necessity. He puts Japanese citizens in concentration camps for 4 years during the war out of necessity. So necessity is always the out, and I think the listener is worried about that. He's worried that his rights will be protected by the system in general, and he doesn't want to vote for anybody whom he thinks might plead necessity in dealing with him if he is either a victim before the court or a defendant before the court.
No, I'm going to, David, I'm going to remain independent, impartial, and fair, and I think that's the simple rule in my mind when looking at an issue like that.
Well, getting back to my question, Mike Little, about whether cases are adjudicated or administered, it's important because an adjudication is what a criminal court judge is supposed to do. He's supposed to decide based on the law the dispute between the two parties, the victim, the state, and the accused. When it's administered, that's a completely different process, because there it's all in state jurisdiction to begin with. You administer a case when it's in administrative jurisdiction, which is the jurisdiction where agency trials are held. I was involved in agency trials in the past. I was tried in agency in the Department of Safety in the bowels of the bureaucracy. So that case was administered by a hearing officer in a contested case. But you're not administering cases, are you? You're adjudicating cases.
No, in my private practice, I've represented people and handled administrative hearings, and the burden or the test on the petitioner is by a preponderance of the evidence. It's much less than a criminal case, but it is civil in nature. You're not really putting someone in their liberty is not at stake. Those are
right. It's at equity. It's a dispute among people in contract.
Correct. Those are different. In criminal court, the burden of the state is beyond a reasonable doubt, and if a defendant is found guilty in a case, then the court puts down a judgment based on that finding.
We have an email here, and the question is: can a jury ignore everyone? Can a jury ignore the judge's instructions and find a defendant not guilty, even though the evidence supports the verdict of guilty? In other words, is there the right of my listener, a jury member, to nullify the whole thing and just throw the whole thing out, regardless of what he might hear from the bench?
Well, that is a question about jury nullification, and jury nullification is not, it's something that we cannot get up and argue in the state of Tennessee. But what a jury does behind
What do you mean by that?
Well, it's not permissible. We cannot get up and say you have to ignore the law. We cannot do that as officers of the court.
Well, no one would say you have to ignore the law, but the question is, can you ignore the law?
Well,
can the listener ignore the law?
And that's what I was getting ready to comment on. What the jury proceedings are private. They happen behind closed doors, and what happens behind closed doors, we don't know. We don't know, and then they don't have to reveal that at all, unless there's some huge impropriety or someone bullies somebody or threatens that, and that comes to light. Then that's obviously and it ends up in a guilty verdict. Then that's obviously some interest of the defendant, because again, their liberty is at stake. But if a group of 12 don't like the case, and they decide that they don't like the case, and they find someone guilty or not guilty, depending on what the situation is, that's the defendant has the right to appeal. State has the right to appeal, but unless it's a not guilty verdict.
Well, our state constitution, and I don't have it here in front of me, says that on the point of libel, in the reference on libel, juries decide the facts and the law. So there is some explicit reference to the jury having the authority to judge not just the facts, but the law itself in a particular prosecution.
That's correct. They're the judges, the facts and the law as given to them by the judge.
Well, okay, the phrase "as given to them by the judge" grates on my listeners' ears, Mike Little.
Okay. Now, well, the listener has to understand, and I, it's good that we are concerned about what happens in criminal court, because someone's liberty is at stake. And that's what a judge has to remember. And that's the importance of, I think, experience. But the court has to remain independent. And I know I could repeat this a lot. The court has to remain independent, impartial, and fair, but he has to apply the law because he's sworn to do that.
Right. And he has a duty to do that because he swore to do it before God, taking the oath of office. But the jury hasn't made that promise. It simply is, and I would say that the jury is a judge of the law, and its members can decide in the face of all the evidence. If they don't like the apparent malice of the prosecutor on the defendant, or if they have some particular sympathy for the defendant, they can say, well, no, we throw the whole thing out. And as you say, it is in secret, and no one can know about their private counsels.
Well, actually, the jury is sworn. The jury is.
What is it sworn to do?
They're sworn to follow the law and render a true verdict according to the law and the evidence.
Well, of course, law, as they hear it, could be the Constitution, it could be the law of God, and the judge, perhaps the bailiff, making that, having them raise their hands, is probably referring to the Tennessee Code, but they may hear it differently, right?
Well, they listen to the facts. They listen to the facts of the case, and they listen to the law as the judge applies it. When they get behind closed doors and they have they do their voting and they have their discussion, and whatever the verdict is has to be respected.
What about reforms in criminal courts in Tennessee, Michael? Look at not just at your proposed tenure on the bench in Hamilton County, but what in Tennessee, say in the next 10 years, would be worthy reforms, making courts more open, making courts more accessible, maybe allowing, I have an idea, but what do you see as a possible thing that would benefit the public and ensure more instances of justice?
Well, more involvement, people becoming more informed and watching the courts in action and see what goes on. I mean, it's open. The court is open to the public. You cannot shut the doors. We have no closed hearings in criminal court. It's a court of record. Everything that goes down in criminal court, you can see it. You can look at it. You can read it. It's actually recorded. The voice is recorded. I think as a criminal court judge, I would always look for ways to improve the system as best as I can, using the calendar and the clock and saving people's time when they come to court. There's a lot of people that come to court your life may not be touched by criminal court, but one day it might. You may come as a subpoenaed as a juror or a potential juror. You may come as a victim in a case. I hope that doesn't happen to anyone out there. You may be a defendant who is accused of a crime, or you may be law enforcement and you may be a witness. All those people who come to our court, we don't want them to have to stay and linger and wait for justice.
This is David Toulis, and caller, you're on the air live at AM 1240 Hot News Talk Radio, and you're on chatting with me and Mike Little, who is an attorney and a candidate for criminal court judge in Hamilton County. What's your question?
I'm so glad you asked that question about jury nullification because, Mike, I covered trials and I watched one where a man was charged with over 50 federal counts, one of them being willful failure, willful failure to file, but one was impeding and impairing the lawful functions of the IRS. The jury found him not guilty on every count. On that one, they were hung. And I heard the judge say, I was in the courtroom, the government spent over $2 million on this case. You go back and make a decision. And to me, the judge was telling the jury to find him guilty. I've seen that over and over again. And in Montana, here's where jurorly lawlessness comes out. Yeah, but what is the law? In Montana, they can't get a conviction for willful failure to file a return.
That's a federal case.
Under Title 26, there's no requirement to file. So the government will charge you with willful failure to file without under Title 26 being a requirement to file. So the Montana citizens are educated, and no longer are those charges brought up against people in court. It leads
All right, what's your
to my
question?
Of federal tyranny.
What's your question?
That you practice in federal court. What kind of tyranny have you seen in the federal courts in defending individuals, and how would you change it? Thanks, Mike.
Well, I've not witnessed any tyranny in the federal courts that I've been in. Now, what I've witnessed in federal courts are the harsh laws. I'm sorry, not the harsh laws, the harsh sentencing laws, which I think are being taken a look at. There are some of the sentencing laws are appropriate, but there is the fellow who gets, or the lady who gets sometimes caught for the first time, and they're involved in a large conspiracy and end up spending a great deal of time in federal prison. Those are pretty harsh, and I think that there are people even judges are beginning to take a second look at that and becoming vocal about it. The comment that you made about the judge making the comment, I would never say something like that. I would again, independent, fair, and impartial. I would never say anything to sway the verdict of a jury one way or the other.
Well, I wanted to ask Michael a question about a possible reform. What would happen if we could have live streaming coming from a cell phone propped on a little tripod right between the defendant's table and the prosecutor table? Every case is streamed live into the cloud, and anybody can watch a case live anywhere in the world. Would that be, especially in these kind of Wild West corporation courts, sessions courts, and city courts, where there's a lot of, I think probably a lot of offhanded abuse, would that be a possible reform, Mike Little? And could it ever happen in Tennessee? Well,
it could happen. When I first started practicing law, a camera couldn't come into a courtroom. Still can't go into a federal courtroom, but in state we allow them to come in, and they cover trials, and they're allowed to come in. It's that simple. Now, as far as streaming everything that goes on inside a court, I don't think that's probably prudent, because
why?
There's not always hearings taking place. And so when there's not hearings taking place, there may be negotiations going on, and those negotiations between attorneys have to be private.
That's private, right? Yes. But that would not be held. Those talks are not held in open court, right? They're held in.
Well, sometimes they are when the court's not on the bench. Sometimes they are. Sometimes the circumstances present themselves when they can discuss it.
So live streaming, which probably my listener can do now with his smartphone, he can stream live any event he wants to the cloud. That's not going to happen yet in courts in Tennessee.
No, I don't think so.
Mike Little is telling us. Well, this is David Toulis. We've been talking with Mike Little, who's a private defense attorney. He practices in every jurisdiction that we can know of. Well, I don't think he's had any cases on another planet, but certainly here in Hamilton County and Chattanooga and local municipalities in the area, he has practiced defense law. His opponent in every case is a government actor of some kind, a state actor of some kind, hauling someone before the bar for an offense. We asked him about paper crimes. We asked him about victimless crimes. And in a nutshell, your take is there really isn't such a thing as a victimless crime. If it's a crime, it's a crime, and there's an offended party, and that party's interests have to be served by the court.
Right. It's against the peace and dignity of the state if it indeed is a crime. And yes.
Mike, thanks so much for joining us. How can my listener find out about your campaign?
Vote MikeLittleJudge.com. That talks about my history, and they can send me a message if they want me to talk any further. I'd be happy to answer any questions. I think this is a very important election. I'm on the Republican ballot in the March 1st primary. There's no Democratic opposition, so whoever wins this primary will be unopposed in August.
The competitors are Boyd Patterson, prosecutor, and Tom Greenholz, who was named by the governor to have that job for now. This is David Toulis. Mike, thanks again.
Thank you.
I do appreciate your giving me a few minutes of your time, and I ask you to tell a friend about our show and tell a friend about AM 1240. Hot News Talk Radio.